organization. So they're good panelists. They're going to go through a little bit of slides. Jordan's going to moderate. He's going to try to throw some stump questions at us. So I think you'll learn a lot. So Jordan, let's go ahead and kick off the panel.
All right, thank you guys. I only have one microphone, so I'm going to speak really loud. I'm going to pass the microphone off to the panel. Before I do, I would ask, this is an open conversation. So if you guys are going through these topics like we are, we're going to have Jim, Craig, and Dave share their expertise and their wisdom with us. But if you have specific questions, feel free to popcorn this. We want this to be interactive as much as we can. I will moderate and move forward if there's no questions, but please, you get some free tax and legal advice today. All right, we're going to start off with the state planning mistakes. And Craig, it's no rhyme or reason that I would say our number one planning mistake is clients and documents. Can you explain why that is?
Well, first of all, I appreciate having the relaxing portion of the evening because after elections, inflation, national debt, and stock markets, I just get to talk about death and insanity, which to me is a lot more relaxing, a lot simpler, and a lot more certain. Yeah, I mean, one of the first problems people have in terms of estate planning, probably the biggest, the most obvious, is not having documents. One of the most probably frustrating things is when someone dies without the family members around them or the people they want to get the money, and it's very clear who they cared about and what they cared about, and yet because they didn't have any will, people that they don't care about are going to receive their assets. And there's nothing you can do after the fact about that at all. And a more even common situation, the documents that everybody should have in place are a will, a financial / general / property power of attorney, and a medical power of attorney with a living will. Revocable trusts are a great tool, but they're kind of an option. They work great for some people, but at the very least, the floor is having those documents. Powers of attorney, people don't realize how critical those are. A married couple, you can be married to your spouse, and if you haven't done that estate planning, even if you've done the wills, but you don't have powers of attorney, and one of the spouses becomes incapacitated and cannot act, suddenly that other spouse finds that in addition to the difficulty of caring for a spouse who can no longer care for themselves, that they don't have the legal authority to take certain actions. They can't refinance their home or sell their home, which requires both signatures. They can't sign on a retirement account or investment account that's just in the name of that surviving spouse. And when they come to see an attorney like me, this is when we give people really bad news and say, well, your only option, and frankly it's necessary, is we're going to have to go through the court process of a conservatorship and a guardianship, which compared to other legal things we deal with is very intrusive. Unfortunately, due to some changes in our state law, it's becoming increasingly difficult and expensive and can absolutely become a nightmare for someone going in. I'm just trying to take care of our own stuff together, and I've got this court accountant asking me to file a full annual accounting documenting every cent I spent. And so these are the lowest hanging fruit is to make sure you have those documents in place.
Absolutely. Yes, Dave.
Craig, how often should you have your stuff that you put together, how often should you have that looked at?
I mean, a gold star, if nothing else has changed, is probably about every 5 years. Okay. And that usually hangs most of all on those financial powers of attorney, which are in some sense the most sensitive documents. That's the gold star. Okay. But not having them at all is the biggest problem of all.
Thank you.
And then go.
Do power of attorneys expire?
Not specifically, no. But there is a informal inverse acceptance from banks and financial institutions based on how old they are. So the newer they are, the more up to date they are with the state that you live in, and any additional changes to law, the more likelihood that they'll be accepted. Some of the other problems, go to people kind of unfortunately doing documents themselves. There's the computer software program, and I don't say this for self-interest because I hate to tell you this, lawyers make more money off people trying to do estate planning documents in the long run themselves than they do charging people to do the documents and getting it done correctly. An example of this, and it's funny in a sad way, how these things can be messed up, because it's not necessarily that trust that comes out of LegalZoom or something like that is wrong or has a problem with it. It's that the clients fail to implement them appropriately. So for instance, we've seen this exact example. Someone does one of those programs and says, I'm going to do a revocable trust because I've heard that's better than a will, and I heard that's avoiding probate. It sounds like a great thing. And they do a trust and they say, this is the person that I care about the most in my life and I want them to get everything I own when they die. But there's and what do they own? Well, they own an investment account and a house. And after they sign that trust, though, they don't do the work that usually gets done of transferring the investment account or the house into the trust, which is one of the reasons you have a trust, so you can avoid probate and put stuff in. But not having them in isn't the big problem when you have properly drafted documents, because if anybody probably has gotten a trust done by a lawyer, hopefully anybody who knows what they're doing, at the same time they had you sign a trust, they had you sign a will that says, whatever I leave, if it's not put in the trust for some reason by the time I die, put it in the trust anyway. So if the person had done a document like that, might have gone through probate, but the right person would have got the property. Instead, they had no will, they had nothing in the name of the trust, they had a trust that clearly said, when I die, this is the person I want to get everything, and that person got nothing. And the person's family that they were very estranged from got everything. And there's nothing you can do. So there's a lot of this, it's by the time you know you did something wrong, it's too late. And there's just some more, little things. We tend to, at our firm, keep original documents for clients just because we found that is the safest. Sometimes when clients keep documents themselves, they will go missing because these documents, as I said, are intended to be used in death or incapacity. So what happens when someone is getting more confused, more disoriented? Is it likely something might go missing over their house? And if so, there's certain documents that if you can't find the originals, the law presumes they've been revoked. And a final thing people sometimes do, and it's why we like to give people copies because they can do whatever they want with them, sometimes people will take an original will or their original trust and start marking things on it. And that's almost a guarantee of litigation as some people argue about what those markings meant.
Absolutely. Well, that goes into number 2 a little bit. You talked about accounts and the titling and the provisions and getting the correct titling on your house or any assets you have. We did not go to school to realize what the difference between a community property account is and a joint account with right of survivorship. There is a whole slew of different account titlings, and it's really important to make sure that that's right. Craig, can you walk us through a few incorrect ownerships or titling issues that you've come across?
Sure. One of the general ones is if people do a revocable trust, not getting assets placed into the name of the trust. And that's not as simple as saying put everything in your trust, because there are details and nuances. Retirement accounts are different than life insurance policies. So usually you want to work with your attorney and your advisors. And at the risk of sounding like a shill for the Underhills, it is so much easier when I work with clients who work with Jim and Jordan, and I will say, or with similar professionals, because usually when I do the trust, in fact, this happened this afternoon, I finished signing a trust with a client of Jim's, and afterwards I can say, okay, I've done the deed for your property, that's done. Now, if it's okay, I'm going to email Jim and Jordan, copy the documents with instructions about how they should do their beneficiary designations. Then someone, it's not you, but probably someone over at that table, yes, does all the hard work of filling out those forms, as opposed to the clients who are kind of DIYers on their financials, and I have to say, well, you got to go take this to Vanguard or Fidelity or Schwab and take whatever religious artifacts and voodoo that it's going to go smoothly. So that is something very helpful. But even without a trust, even with a will, just keep in mind that your beneficiary designation's ownership has to match up. Let's say you're a person that has a niece and a nephew, and at one point the niece is your favorite family member, you want her to get everything, and you didn't do a trust, you did a will, and you've got beneficiary designations that say, when I die, my retirement account goes to niece, my life insurance policy goes to niece, and by the way, that's most of what I own. And I also do a will saying niece gets everything. And then 10 years later, there's a falling out, hate niece, love nephew. He's suddenly your new friend, and you go to the attorney and say, redo that will, take out niece, add nephew, I want him to get everything. And then you die. And it turns out very clearly who you wanted to get the assets, but life insurance company and IRA custodian doesn't care what your will says. She's listed on the beneficiary, she comes in with a death certificate, it's her money, and really nothing changes that. And there's a whole, people can have a home with a beneficiary deed on it, which is a very convenient thing in certain circumstances, but sometimes they leave a beneficiary deed hanging out there and then go change their will and forget that there's a deed that's kind of hidden because a beneficiary deed doesn't really show up on the assessor site, and when they die, the wrong person gets the property. Another quick thing about beneficiary deeds, sometimes people like these to avoid probate without doing a full trust, but there are risks with those. If you have a single responsible adult beneficiary, beneficiary deed can work very neatly. You have 4 beneficiaries. I tell you I would rather do the probate 5 days a week than I would deal with 4 people owning that property together and hoping not one of them is disagreeable or delays or unresponsive.
So a quick note on the trust. There was a study in Arizona a while back. There was a study on trusts in Arizona a while back when the trustees, grantors died. How many trusts in Arizona had gone unfunded with at least one asset? Anybody have an idea of how many that would be? They didn't fund. Over 70% of the trusts went unfunded, partially or fully. So many people we see coming into the office. That's why every year in the fall, we review the estate plan, we review the beneficiary designations, and we review the title. Because that trust, they thought, did everything. They did it on their own, or somebody did it for them that they knew, and they came in, they didn't know what to do from there. And so none of the assets. And they didn't have a pour-over will, which was the will Craig talked about, so there wasn't good execution. And you know what happens at that point? All those assets fall outside, goes to probate. Does anybody want to go through probate?
No.
It's not something that's terrible in Arizona.
Craig and Dave can.
It did bother me with my parents, I just did it. But
Arizona's pretty
we try to
efficient.
save it. It optimally, you save it and avoid it and reduce some expenses.
Exactly.
But it is not the nightmare some people who try to sell a trust to everybody make it out to be.
Yeah.
I will say that.
In California, if you have a will and go through probate, the cost is a percentage of the estate. So $1 million estate, I don't know, maybe it's $30,000, $40,000, $50,000. What's the cost
That's
of
the
probate?
attorney's fees.
The attorney's fees are a percentage, and guess how this comes about? They decided they were gonna put a maximum on what attorneys could charge. So what does every attorney do? Charges the maximum, yes.
Talking about the beneficiaries, the other thing to keep in mind, I ran into this personally this past year, make sure the secondary beneficiaries are identified on the accounts and the IRAs. My in-laws have both passed away. My father-in-law declared my mother-in-law as his beneficiary. He passed away. There was never a secondary beneficiary. She passed away. She had him as the beneficiary. He'd already died. There was no secondary beneficiary. That whole thing got elevated about 3 levels up within Schwab before they could figure out that all 5 of my wife and her siblings were going to be able to get that money, and they're still in the process of getting that resolved. So a little thing like that, that just hadn't been considered. So.
And the bottom line is, if you have any questions on beneficiary designations, ownership, title, and that's what I always encourage my clients. We're not trying to nickel and dime people. If people call, if you have a question, what should the beneficiary designation be on this trust we set up, or opening a new account, or buying a new property, or ask your advisor. Frankly, whoever you ask, someone's going to get you pointed in the right direction, but you just need to think about that.
All right, number 3. We have wrong fiduciaries on the account. This can be summed up as wrong people on the account. Can you explain what clients should look at when listing out trustees, executors, executrix of accounts, and what should they look out for?
Very good. Yeah, I mean, to boil down and try to minimize what I do, there's 2 main questions for clients. Well, who do you want to get your stuff when you die? And who do you want to name to make all these decisions when you can't? And there's a spectrum. There's, your financial agent who would manage your assets if you become incapacitated. It's part of what a trustee does as well. Who would make medical decisions for you if you cannot speak for yourself with a doctor or hospital. And who handles your estate when you die, which is either the executor or personal representative under your will, and also the trustee under your revocable trust. It kind of boils down to, when you are picking people for these situations, you're trying to fill a job. And it should not be an emotional choice. It should be, who do I think's going to do the best job? Who do I think's going to be able to be responsible, have the time? They don't have to be a lawyer or a CPA or an advisor, but they have to be the type of person who will listen to the experts and follow their advice, who can be timely and responsible and organized. That's kind of a minimum, and honest. Sometimes clients are agonizing, well, I don't want to name, this child's terrible at doing this, but I don't want to insult them and hurt their feelings by not doing it. And believe me, you'll hurt everybody's feelings a lot more and won't do anybody any favors, including the person you name, if you pick someone who's not well suited for the job. Now, most of the time, people are still choosing family members for these roles, and frankly, I think that's usually, for most people, the right choice. People have grown children that are responsible, and they're able to take it on. That's great. But if you don't, you don't really want to stretch too far, because these jobs can be a tremendous amount of work and responsibility and liability. And it's not something you can just say, well, my neighbor was pretty good. He got my mail that week I was gone. And so maybe I'll name him as trustee of my trust, and that person may not want to spend a couple years managing your care in the nursing home and paying your bills. And so you don't want to stretch too far. There are options out there. Banks and corporate trustees will do that if you run out of options. There are also licensed fiduciaries in Arizona that can be a little more flexible. It's something we do if people need it. But it's definitely not a one-size-fits-all. I don't think most people need that professional role, but it's something that people should at least have in their quiver when they think about their options. I mean, we do have people come in who say, I don't have children, and I really don't have close family members here anywhere near me outside in the west of the United States. What are my options? And so there are options like that for people.
Well, and we're finding, well, we'll get to you just so, we're finding that a lot of our clients are putting, say, a trusted child is a successor trustee or power of attorney. What we're finding is we all move along in life, that there may be that child has their own health issues, or they've moved out of the country, or they've got some issues with their family. And if they get landed on that job of a trustee where they've got to pay a lot of bills, dig into the financials, get the passwords on the computers, whatever, all those pieces, it can be extremely time consuming. So it is an antidote. We can look at that contingent trustee or power of attorney that can be more of a corporate, a law firm that you deal with. The law firm is a fiduciary, a regulatory type issue. They can't, if a child or a sibling or whatever just can't perform the task, or doesn't want to, or doesn't have the time, you've got to back up. So that's a good solution.
And there's no cost either at the estate planning side or really downside to having that backup, that third or fourth choice. If you're going to name someone who's a sibling or even a friend or something like that, and you have someone like the law firm as a backup to them, that's an incredibly different situation than they're named and they're the only one. Because if they can do it, say, I'm happy to do this, I'm fine doing it, great, but if I don't want to do it, I don't have to feel the pressure, I have a very graceful exit.
Yeah.
Right, Patty?
Yeah.
Seth.
Tom, did you have a question?
Craig, quick question. So if your next door neighbor does appoint you, unbeknownst to you as the executive of the state or the administrator,
You can sue him.
is there a mechanism to go to court and get that withdrawn?
And yeah, generally there is, we have the 13th Amendment. You can't involuntarily make people do things. And yeah, nobody has to accept a role under a power of attorney as a trustee or as a personal representative. And, before taking it on for someone you're not close to, they're leaving you the whole estate. It's a little bit different. You're like, well, okay, maybe this job isn't so bad. But if you realize that you're not a beneficiary and you're responsible to 5 or 6 nieces and nephews and ultimately have to account for them for everything, you want to think seriously before you sign on the line saying, I accept this. So you don't have to take that job, and don't let an overeager attorney talk you into that, because that happens. It's like, hey, come to my office. Your neighbor Mary named you in a will, and I prepared the document. Sign here, here, here. Okay, great. We're going to get you appointed, and once you're on that train, you can't just jump off. So.
All right. Number 4 is personal, tangible property woes. Whoa. I'm going to stop there and let you explain that one.
Yeah, it's just interesting because this has become one of the most problematic areas for trust and estate administrations. Usually with the right, we've got some great realtors we work with who kind of know how to do this. Dealing with the actual real estate isn't always so hard. Certainly dealing with financial investments is usually pretty simple. It's the stuff that people have that causes the most problems. Now, if nobody cares about the stuff, sometimes it's less of a problem. You can be donated, etc. If you have specific wishes, most wills or trusts that attorneys draft for people, will have a provision that you can do your own separate list saying, I want all my tools to go to Jamie, I want all my jewelry to go to Joey. I can specify who gets which ring and which, it's up to you. If you don't care, don't feel like you have to care. Usually, unfortunately, the only time people seem to really care about this is when they hate their siblings enough that they're willing to spend $50,000 paying attorneys to argue about $300 worth of dishes and clothes hangers. And I'm not kidding about any of that.
Personal note on that,
Yes.
we had 2 sons, a case where 2 sons inherited the estate from their mom and dad. They went to do go to the house, and one son takes a picture off the wall. He's walking out to his car, a painting. The other son said, what are you doing? He goes, well, that's a painting. And he said, I understand that. Why are you taking that? He goes, well, I gave that to mom and dad, so I'm taking it back. He said, once you gave it to mom and dad, that's an irrevocable gift, so that is not your painting. Those 2 boys haven't talked since. So you really want to do this right and not leave a train wreck for your children.
It may be more what you do when they're 4 and 7, but that lead up to that. But yeah, no, I've had clients who were the children of the decedent, and they had a stepmom they didn't care for, and those kids who were clients, wrote an $8 million check to the IRS without really reservation. But what happened to that $800 saddle that Dad had? That is mine. That is not hers. Also, there's a reality. It's very metaphysical in your own life, because you basically realize that whatever lifetime I've sunk into that metal CD collection, it's not going to be worth anything when I'm gone. It's not going to mean anything to my family.
Annie treasures it.
Well, she might say that while I'm alive, but and that's kind of the way it is. There are occasionally things where people will care about the stuff you've left behind, but most of the time they don't. It's becoming even more so. The things that used to be collections that mattered to people, the china, the silverware. Nobody wants this. The prices of all of it goes down, which means people want it less. So you have to kind of realize, look, if people want stuff, they can have it, but nobody may want this. And sometimes people think, well, I've got this mineral collection that fills my entire house. I want it donated in its entirety to a charity that's going to keep it and put it on display. It's never going to happen. And so you just have to realize there's a mortality to our tangible items that probably has a similar timeline to our own physical mortality in that role. One thing we try to do in the documents, just in our base language, which I've edited based on cases like this, is to say whoever you put as the trustee kind of has final discretion. Because a lot of these documents don't say that. They say go according to the list and then distribute it equally to my 3 kids. Now unless you sell everything and divide up the proceeds, there is no way to physically divide up equally, furniture, chairs, jewelry, golf clubs, things like that. See, I tried to pretend I'm in a sports ball. I'm just golf clubs. You don't want your trustee being sued over the Garbage Pail Kids card collection. Again, I don't have to make up any of these. These are all true. I had siblings who were like dividing equally an estate, $300,000. So there's nothing to argue about, money-wise. But the kids would argue about truly stuff that I don't think it's worth $20 in tangible items, and after spending 20 or 30 grand in legal fees, they finally reached a settlement, and then one of the kids wanted to break it because they found out some photo on mom's wall had been donated to the Historical Society. And that's the way it is. So trying to reduce these things, and at least if you say, look, if I make one kid the trustee, or if I make the law firm or this person the trustee, they can deal with the family, divide it up however everyone agrees, but if there's a disagreement, they can decide who gets what, they can decide to sell things, they can decide if they can donate it to the charity. We don't want arguments about whether that particle board used flat pack from IKEA that was held together with tape was unconscionable that it was donated to Goodwill. So.
All right, and last but not least, in the estate planning mistakes is problems in the...
You had a question.
Oh, sorry, Bob.
Question,
Yes.
Bob?
Me?
Everybody's pointing at you, maybe they're just taking it on.
Talking about the thing called trust protector. But you haven't mentioned trust protector.
A trust protector it's not the world's lamest superhero. It's something in Arizona that can be put into an irrevocable trust where you give someone not the role of the trustee, which is where the real authority and duty and liability comes from, but to make certain changes. We use them in irrevocable trust when people set up trusts that they have to give up control of for tax or other planning purposes, because it's a way to cross our fingers behind our back and say, well, it's irrevocable, but we're going to give this person over there we think who's very nice the ability to make changes. And sometimes that can be built in just specifically on what people want. It can be whatever you want, but one example, sometimes we've had clients that say, I'm naming both my kids as trustee. But if there's a fight, I don't want them having to go to court and spend thousands of dollars. I'm going to appoint the law firm as a trust protector that can break a tie. Or settle an issue when it comes to tangible personal property. A lot of people may not need that, and we try to give the trustee enough discretion, but it's a little customized tool that's kind of not part of your normal forms, but that can be added based on what people want. Sometimes also someone will say, well, I really don't want my kids to have to do this. I'm going to name the law firm as the trustee, but I don't want them to feel cut out, so I'll make the kids the trust protector, and we're going to say that they want to fire the law firm and hire someone else or appoint themselves, they can, and they can get accountings and they can see what's going on.
Okay, final 1 minute close on the estate planning mistakes, problems in the plan.
Yeah, it's just, sometimes people try to make things too complicated. Realize that it's about your wishes, and nothing's more important to me when clients come in and talk about their planning about their wishes. But from the lawyer's point of view, you tell us the wishes, we say, okay, this is how it's the best practical way to do that. Some people, and I'm not going to say it's engineers, because now I've got one son who's an engineer and another who's in engineering school, will try to make things way too complicated, and that's when they really overmanage in the future. They come in with something with so much detail, and you say, yeah, you got to give the trustee some flexibility. If you didn't have flexibility, you wouldn't have a trustee. You just set up an annuity or something like that. So, but that's the short one.
Perfect. Guys, any questions on the estate plan before we move to Dave and the tax planning strategies and opportunities?
So can a trustee be sued?
Oh, yes. Are you kidding? The trustee cannot be sued. And there's nothing you can do to stop that. If someone's a trustee, and it doesn't matter how crazy the individual is, we've got some cases where the Supreme Court has run up and said that they did everything right. The Arizona Supreme Court, not the US Supreme Court. And there's still people making complaints to various agencies and dragging trustees through these problems. So trustees can be sued.
What's the longest estate settlement?
Longest estate settlements?
Settle it
I don't know. Usually that's not the problem. I mean, usually I'd say 3-4 years would probably be a really extended ugly one.
out. I've seen 9. This stuff can go on forever.
Well, I guess I usually quit after 4 years, so.
All right.
George,
Sharon?
Yes.
Just one, is there a standard percentage or amount of a fee that the trustee can charge?
The question is, there a standard trustee's fees? And the answer is not exactly. A professional trustee will have a schedule for what they charge. You know, it has to be pretty clearly defined. As a law firm, we're either charging hourly for the services or we're doing a percentage fee, which is similar to what banks and other corporate trustees charge. For individuals, there is not, but usually they can kind of work off those standards. I mean, if you're charging 10 times as much as a law firm or Northern Trust would charge, then you're probably out of line. So usually the trustee has to work with a lawyer to say, okay, what do you think I can charge? You look at what was actually involved, how much work was involved, because it does vary. Sometimes it's closing out one brokerage account. Sometimes it's selling a business and 12 pieces of property. So fiduciaries can either keep track of their time and try to come up with a reasonable hourly rate, but I do think we're getting more away from that and just trying to say, look, this seems like a appropriate flat fee to charge. We'll let the beneficiaries know. Nobody objects, it's a fine fee. Yeah.
All right, Mr. Dave Barber. I don't know about you guys, but I always stay up with the tax law changes from year to year, knowing the tax brackets, right?
Your nose is growing.
Yeah, I don't think anybody does. So today we want to go through a few opportunities, a few mistakes, a few updates for 2024, a few things for you guys to leave here with saying, aha, I should go and look at that to do something different or at least be more knowledgeable. And number one comes to point RMD planning. Who knows what RMD stands for? Help all of our clients do.
Yeah.
Required minimum distribution. Dave, take it away. RMD planning, mistakes and opportunities.
Okay, well, if you thought the rest of this has been riveting, you're really So, for many, many years, required minimum distributions from IRAs was very straightforward and very consistent for a very long time. Well, you can throw that out the window at this point. Now, we've made, since COVID first occurred, there's been a number of changes to that. And so now, if you're born, I actually had to print this out because I could never remember it. If you're born before June 30 of 49, you start taking your RMDs at age 70 and a half. If you're born between July 1 of 49 to 1950, through 1950, it's 72. If you're born between 51 and 59, you start at 73. And in 1960, a year later, it's at 75. So they've really pushed out when you have to start taking money out of the IRAs. So for a lot of people, that's a good thing. Obviously, you can still take money out any time. You know, before you're 60, you can take money out. You just pay a penalty on the distribution. And once you turn 60 and a half, then you can take money out and just pay the income tax. You don't have to pay any penalty on it. So having said that, you should also know we've had a number of clients too who've retired, and for a period of years their income is very, very low. So we've actually had them take IRA distributions in their 60s because they're maximizing those 12 and 15% tax brackets and able to get some of the money out of the IRA, and they won't have to take such large distributions later. And a lot of times they're just moving that money from their IRA account over into their investment portfolio as well. So there's some things to think about there, and I'm not even going to go into they've also changed rules on inherited IRAs. I'm not even gonna try to go down that rabbit hole because the rules there are different depending on age and depending where you live in that, right? Whether you inherited it from a spouse or if you're an heir, and so anyway, just be aware that those are changing. And one of the other questions I get a lot of times too from people who haven't started taking their RMDs is, well, how much am I gonna have to take? And generally it's, in the old days, it'll be a little higher now when it was 70 and a half. You figured about 4.5, year one, you're gonna have to take about 4.5% of whatever the balance is in the IRA. And as you get older and your life expectancy gets shorter, that percentage goes up. But also, if it's invested properly, the balance in the account's also gonna increase too. So those distributions are gonna go up probably, right, Jim?
Definitely.
So,
That's his fault.
yeah, that's his fault.
Anybody know if you fail to take your full RMD, what the penalty amount is, what the percent of the penalty is?
10%.
No.
Anybody? Guess?
50?
Somebody said 10, it's higher,
50? 40?
higher,
50.
50%. No.
So,
So you do not want to make a mistake in this arena.
interesting on that, that's also, Jim, as part of the Secure Act, they reduced that to 25%. But we've had that happen a number of times, and every time we've got IRS to waive the penalty. They almost waive that penalty automatically, but you have to do a catch-up distribution, don't you, Rebecca? You have to do a catch-up distribution in the year that you realize it, so that you make yourself back on path. So, I'm sorry, but
Yes, Andy.
she was staring, right?
My understanding is,
Well, you're talking. So-
my understanding is that the company has to notify the individual the required RMD from each individual fund. At least that's something I've always received.
The question is it true that the company, the custodian, has to notify you of your required minimum distribution for that year?
The answer is yes, that's assuming the custodian is good. Which is pretty much how it works. We've had clients say they never got a letter on that. They didn't know. You can take your RMD out of one IRA if you have multiple and not take any out of the others.
Yeah.
We had a client that wanted to take their RMD in December so they could let the investments go the whole year. Went to Europe, got sick. We couldn't get a hold of her, missed the RMD that year. Now, and it was big, so that 50% at that time penalty would have been a lot of money. As Dave alluded to, we were able to write a letter to the IRS. It used to be kind of called a one-time forgiveness letter. Well, we had a client, it's a good friend of some of the folks here, whose dad missed 5 years, which was probably going to be, I think it was somewhere in the $80,000 to $100,000 penalty. We wrote a 5-time forgiveness letter to the IRS, and guess what? They actually accepted it, because it was only one letter. So he was able to get by with it. I wouldn't trust that though. So,
Yeah, I don't want to put my faith in the IRS and waiving penalties for me personally, so let's not have that happen. All right, number 2 is clients with more charitable inclination. We have a lot of clients now coming to us wanting to transfer some of their assets, one of their living to charities. Can you walk us through some of that planning technique?
Yeah. One of the things that happened in 2017 when they increased the standard deductions for income taxes is a lot of people weren't getting benefit from their charitable donations anymore because they weren't hitting the threshold where they're able to itemize their deductions. So 2 or 3 things kind of evolved about that same time. One was creation, well, not creation, but they already existed, donor advised funds. So you can give a pot of money to a foundation like Southern Arizona Community Foundation or the Jewish Foundation, et cetera, in a donor advised fund, and they'll hold that and they'll disperse that to charities over a period of time on your behalf in your direction. So people were doing that in order to bunch their donations together in 1 year when they gave the money to the donor advised fund. So that was one good way of doing it. The other thing people were doing was they'd kind of double up their charitable donations. In December of this year, I'm going to give my 2023 and my 2024 typical donations, so at least I get benefit from those in one of the 2 years, because otherwise I'm not going to get benefit in either year. And then the third thing is making charitable donations directly from your IRA as part of your RMD. You can do up to $100,000 a year from your required minimum distribution to go directly to charities. We've got a number of clients that take advantage of that. It works really well. The can only be done with the RMD if you're 67 years old and you want to send money to charity from your IRA. That's not going to work. It can only be done as part of an RMD distribution. One of the things I'll recommend that if you do that, make sure you're real clear to your tax preparer, because there's really no designation on the 1099-R form you get at the end of the year for your distributions in relation to these qualified charitable donations. So a lot of times clients, we've had clients who've actually doubled that up. They give us a list of charitable donations. They don't tell us that $15,000 of that, you see where I'm going with this. Yeah, we actually came from their IRA. So you just have to be really clear. I'm like you, I'm surprised they've never modified the 1099-R form to present that separately, but they don't. So just make sure if you do that you're real clear with your tax preparer on how that's done.
Perfect. Number 3 is Roth conversions. So what is a Roth conversion? Is it right for you? That may depend, and there might be a potential 2-year closing time in order to actually make this really worthwhile. Can you explain that, Dave?
Not very well. This is one of my least favorite things. It really is. You can take an existing IRA and you can convert it to a Roth. And when you do that, though, you have to pay the income tax on it. So for us as CPAs, it's like counterintuitive to everything we do, where we're trying to push the tax burden down the road. But some people do this. It's fairly common. And the advantage of doing it is that once it moves into the Roth, it grows tax-free thereafter. And so when the money comes out on the back end, it's not taxed. And if you pass away and still have money in that Roth IRA, it goes to your heirs tax-free as well. Unlike the regular IRA, an inherited IRA, the beneficiaries are going to have to pay tax on that. But there's a lot of, it's actually a tough calculation to try to do, to try to figure out what tax bracket am I in now, what tax bracket am I going to be in when I retire, how much is the portfolio going to grow between now and then, when am I going to die, just all those kind of things. So,
Those are easy.
oh, jeez. So, yeah, I literally cringe every time a client brings that up. And one of my clients converted $100,000 last year while they were still working and paid 37% tax on it. I just couldn't talk them out of it, but that was what they wanted to do. So,
Sounds like they need a good financial advisor.
yeah.
All right, number 4. Oh, the 2-year window. The 2-year window is the tax brackets revert back to the Tax Cuts and Jobs Act of 2017. So your tax brackets, if you're in 22, goes to 25. So if you arbitrarily wait to do this until 2026, if nothing else changes, then you do this Roth conversion, you're paying 3% more tax in the same bracket. So the 2-year closing window is, if it makes sense for you at this time, speak to your financial advisor. Might as well do it now before the tax code changes and reverts back.
Maybe.
Yeah.
All right, number 4 is a gift and estate tax.
Yeah, on gift tax, probably the biggest misconception, and I get this question a lot, is people just not understanding gift tax and gift tax returns. So people will say to me, so if I give my kids a gift, do they pay the tax on it or do I pay the tax on it? And the answer is neither. So the purpose of the gift tax return is to report gifts made in your lifetime that are over above the exempt amount. The exempt amount for 2024 is $18,000. So if you give a gift greater than $18,000, you should prepare and file a gift tax return, which is just an informational return that goes to the IRS that reports you gave this gift, how much, and who it went to. And then what that's ultimately used for is in connection with your estate and your estate tax return to make sure that your total estate wasn't greater than the exemption amount, which are currently over $13 million per individual. But as Jordan mentioned, in 2026, that'll theoretically drop back down to like $7 million. So again, nobody pays tax on a gift, but a gift tax return should be filed. The other thing that's not commonly understood is, so like if Jim and Sue want to give both their boys gifts, Jim can give $18,000 to Jordan and to Jordan's wife, and you can give $18,000 to your other son, and Sue could do the same thing, and no gift tax returns would have to be filed.
Dave, that's what I call this paycheck.
Jordan's adding this up over here, 18 times 2.
Trying to help you out, buddy.
Thank you.
So no gift tax even has to be reported on those situations, but yeah, each spouse can give gifts to whoever they want up to that amount, so.
Perfect. All right, 2 more guys, and we'll get out of here with a potential gift. So hang on, thank you guys for staying late, we appreciate it.
Untaxed.
Untaxed gift, not recorded.
It's under $18.
Yes.
18,000.
We talked about the Secure Act 2.0. There's a lot of provisions. They're still working their way through the system, actually, to see how they're going to implement some of these. But Dave, can you give our clients just a few tidbits of what that Secure Act 2.0 would mean to them this year?
Yeah, just a couple things. We touched on a lot of, the thing we touched on about the change in required minimum distributions was connected with that. There's some very specific features to it as well that probably wouldn't apply to a lot of people in the room. But a couple of other things of note is that starting in 2025, people have received larger catch-up contributions to their 401k plans. So that's one feature of it. Another one that's kind of interesting is 529 plan assets, which are the educational fund assets. Those can eventually be rolled into a Roth IRA at some point. There's some limits on that too. And speaking of those 529 plans, that's another area of misconception. The money that goes into on your Arizona return, you get a deduction for the amount that you put into the 529 plan, up to $4,000. It's not a credit, it's a deduction. So if you put $4,000 in, your Arizona tax rate's 2.5%, you're really not getting hardly any tax benefit out of that. But it goes in there gross tax free, and it's there for your kids or grandkids for their secondary or post-secondary education. So,
It's so your accountant that you did it.
yeah, I know, right? That too.
All right, last but not least, portfolio tax liability.
Yeah. Dividends get taxed, if they're qualified dividends, they get taxed at 15%, which means if you've owned the stock for over 60 days and declares a dividend, it's probably going to be a qualified dividend. There's also capital gain dividends that come out of a lot of the mutual funds where sales occur within the mutual fund and that's reported as a capital gain dividend to the taxpayer. And those are a little hard to predict, aren't they, Jim? I mean, you probably know some funds that are going to do well with that, and then a lot of times it's just hit or miss.
They track, that statistic, and you'd be surprised at some of these funds that are perform well, but the tax liability on them, if you factor that in, they don't perform as well. Because it's net of taxes, net of fees, your performance. So
And I wanted to mention the capital gain dividends because we've had clients who, for one reason or another, had large capital losses that they're just carrying forward from business that they had that went bad or whatever. Well, then eventually, if they're able to generate capital gain dividends, that will offset those capital losses and won't be taxed at all. So it's important to, and Jim's office does a great job of this, correlating the tax and the financials together. But everybody needs to be able to communicate. Jim needs to know if you've got capital losses that are carrying forward that can be used. And you never want to assume that Jim knows your tax situation. You never want to assume your CPA knows your portfolio structure either, because all we see at the end of the year is the 1099 that just shows the income and losses in the account, not how it's structured, not how it's developed. So anyway, it's important to keep everybody in the loop and establish a dialogue between your tax preparer and with your financial advisor.
So the other shoe of that is this is not for IRAs, right? So IRAs, you don't have to worry about capital gains. IRAs are ordinary income when they get distributed. You can't get around that. But for everybody who has trust accounts or individual and community property accounts, joint, those are taxable accounts. So each year, as there's buying and selling going on, you're going to kick out a capital gain or capital loss. Some of it's short term, if it's sold under a year of holding, or long term, the tax rates are different. So it gets complicated. But as you look at the portfolio, the goal is, if you can, to neutralize the tax. Well, the only way you can do that is oversee it closely. So if some holding may be down, but you want to keep the holding, you're the portfolio manager, you can sell that holding maybe at a loss in March, You buy the holding back 30 days later, that allows you to book the loss. The IRS won't let you do that, just sell it one day, buy it the next day and book a loss. Once you book that loss, say in March, that holding could grow or other holdings grow to the end of the year. You can take some capital gains and offset that loss with the gains, reset your basis. They call it tax loss harvesting. You're kind of harvesting these, and it's very effective. And it's not generally harmful to the portfolio at all. And you can neutralize it. And we see clients all the time that walk in, and maybe it was a negative year, but the mutual fund manager sold something that had 5 years of gain. The account lost money in the year, and they go to their tax provider and they have $30,000 capital gain. And that's not a happy day for you, right?
That's right.
When that happens. So it's keeping track of it. It's not easy to do, but it's something you want to ask about.